Yeah.
Hello, everyone. Good morning. This is Anish on behalf of the National Law Training Institute. Among us today, we have Shivaraman Raghuraman, who scored an All India rank of 12 in CLAT 2022. He has an exceptional command over the legal reasoning section, and that is conspicuous from his marks. He scored around 37 out of 40 in the legal reasoning section. So, a lot of you request us or asked us basically to conduct topic specific classes, master classes by mentors who did exceptionally well in during their time. So in that pursuit, we today have the first session based on the legal reasoning pattern, and Shivaraman will be solving around 20 to 25 questions. So basically, this is an entirely practice-based question solving session, so that you get to know the approach of a CLAT topper, how that person particularly approaches the legal reasoning section, what goes in their mind while solving the question, and what is their general mindset while they eliminate two options and then ultimately choose between the two confusing options. So over to you, Shivaraman. Let me know when I should share a slide. Also, although a quick introduction would be great.
Yes. I'm Shivaraman. I was I had well into the 2022 paper. So, like in legal reasoning, I think one of the most important things that you have to keep in mind is to kind of apply the principles that you have very strictly, and to not be influenced by any sort of other biases or emotions in your decision making. Because I found that was a big problem while I was doing it. I often got influenced by what I otherwise knew, or by my emotions or something like that. So make sure that you keep the principles of the principles given in the passage. You kind of apply them very strictly, and yeah. So that's my main broad advice for legal reasoning. So I'll start the
Right.
yeah. Okay. Okay then. So this is the first
Yeah,
passage.
Shivaraman, sorry to interrupt you. What do you like? What do you think? We should give them 5 minutes to solve, to first read the question, and then we'll solve together.
Sure. We'll yeah.
Yeah, we can do that. First, give them like 5 minutes,
Should
four
I
five
like
minutes to read the passage.
yeah.
All right. You can use a timer if you want to in your mobile phone.
Yeah. I'll put timer. Yeah. Okay.
Shivaraman, can you increase the font or can you zoom in?
Sure, is this enough?
Yeah, this should be fine.
Yeah, okay. Yeah, okay. The time's done. Then I'll go on to the questions. You're muted, Anish.
Yeah, yeah, Shivaraman, you can carry on.
Yeah, okay.
I, yeah, I
Yeah,
leave the
okay then.
session. If you want anything, just drop me a message on WhatsApp.
Yeah, okay then. Sure. Uh, so then, the first question, for like first thing I'd suggest is to just read the question and like kind of go option by option. Don't let the other options influence your thinking. Just go like the options one by one and look at them in a very isolated manner. So the Raj Mahal was a five-star hotel in Delhi. Once a fire broke out in the building. When B was stuck inside the building on fourth floor, C, a fire rescuer, asked B to jump into the safety net they had arranged. C knew there was a high chance of B's death. B jumped and could not land properly. No, okay. So the the main thing the main thing here is sort of the question of intention, right? So there you sort of look into you sort of look into whether there was an act and whether there was an intention. So then we'll go into the options one by one. So C shall be held liable for culpable homicide as he was aware of the risk of death in the jump. Um, so C shall be so he was aware of risk of death. So I mean, just knowledge is not enough, right? So this means that there's a risk. He knows that there was a risk of death, but that doesn't necessarily mean that he was aware. He had an intention for the person to die. So the A would be eliminated under that option. So then B, C shall be held liable for culpable homicide as he intentionally asked B to jump after knowing that it might mostly cause death. So this is so once again intentionally asked B to jump. So he did while he yeah, like he knew that it would cause death. He the knowledge that the doer is likely to by the act to cause death. So again, the likely is kind of not I cannot really prove it because uh yeah because he knew that the act might cause death, but once again he did not intend to cause the death of the person. So this like again here it would this requirement would not be met. So once again B would be wrong, and C shall not be held liable for culpable homicide as there was no intention of causing death in the given case. So yes, there was no intention. So this would be this is we like for now at least since we have not read D yet, we'll just keep it aside. And C may or may not be held liable for causing death based on the further facts of the given case. So these kind of like options, they are often wrong because they usually you can often safely eliminate these sorts of very inconclusive or very vague options. So then there we can go with C. So that's how you do it. So then that's why the C would be the correct answer in this case. So then let's move on to the next question, 67. So I'll just maybe give like a few like 10 seconds to read the option to read the question. Yeah, okay. I hope you guys have read the question. So, um, yeah. So once again, we'll go through the options one by one. D shall not be held liable for culpable homicide as he did not have the intention of causing death of A. Uh, so once again here he did not have the intention of causing death of A. So this is like he did not have the intention of causing death of A, but he did have the intention of causing death. So that so we'll just park this for now. D shall not be held liable for culpable homicide as the requisite conditions of culpable homicide are not being fulfilled in the current case, in the given case. So so once again, we'll just keep this aside. So D shall be held liable, and murder. Again, this thing is wrong because the murder because there's no mention of murder in the passage at all. So we'll this is ultimately wrong because we can't go beyond the passage. So then between the two these three questions, so then between these two, we can safely say that D would not be the right answer if he were not be held guilty or liable. So that's because A is more specific, and usually, if you have a specific and general answer, you should usually go for the more specific answer because, uh, like in these sorts of general answers tend to be more very vague. So that's what so you should usually try to go for an answer which is closer to the principle. So then the question is between A and C, which is basically is he guilty or not. So we'll take a close look at the like the requirements. So the act must have been done with the intention of causing death. So in which case, yes, there was an intention to cause death. There is no necessity that there was an intention to cause death to the particular person that died. So while there's a particular principle of law that would make a guilty so but we don't really go into that because that's not part of the passage. But just given based on what's in the passage, he has an intention of causing death, and there is an intention of causing the bodily injury which is likely to cause death, and not so all these three exist. So he knew that this bodily injury that would be caused by falling is likely to cause death, and he knew that he had the knowledge that he is likely to cause the death of some person, and he had the intention of causing death. So so it is not necessary that the person he wanted to kill, so that kind of goes into motive rather than intention. So then so then he would be held liable. I hope you guys understood that. Okay. So so yeah. So anyone has any doubts? Okay. No. Okay then. So then we'll go to the next question. A went to hunt in Bandagar. I'll just give you again like 10 seconds to read the question. Yeah. So now we look at we'll sort of analyze the facts. So B was relaxing near under a tree near the bush with his girlfriend C, and B died from. So here there was we need to see whether there was an intention to cause the death of some person, right, of some human being. Uh, so here he did not intend to cause death of of any human being. He intended to cause death to be he thought that it was a deer. So and so that here we see we that it was not that it ended up not being a deer, and instead it was this bee. So let's look at the options. So A has committed culpable homicide and A has not committed culpable homicide. So again, may and not possible we can safely eliminate because these are very vague options. You often in legal reasoning you have these two options which you can easily eliminate because they are either very vague or very or kind of just come either based on like emotions or some sort of a value judgment. So in if you see those, just immediately eliminate them because and then you can usually narrow it down to two options. So in this case, it's either A or B. So it's basically is he liable, is he guilty or not guilty? Liable is technically the wrong word, but that's what's used. Liable is you don't use liable for criminal cases. Um, yeah. Uh, so yeah, in this case he has not committed culpable homicide. It's B because yeah he has not because there is no intention to cause death to any human being. So that's why so because of the lack of intention. So we look at the passage on intention to prove intention. There is the act has to be as two types, whether bodily injury in done in a fashion. So yeah, so one needs to prove that the injuries were administered with the intention of causing death. He did not intend to injure that like any particular human being. So again, yes, it's B. So some of you have got it right. Isha, Gaurisha, Tanaya. So um, so anyone has any doubt here? So Sam has a doubt for section 67, the passage near it. Um, Yeah, so once again, yeah, the passage doesn't really say that you need to that there needs to be an intention to kill that particular person. It just says that there was an intention to cause death, right? So it uh, yeah, so there was no intention to cause death to that particular person who died. The But that's not really a requirement of culpable homicide. It's just an intention to cause death, and that death and that act caused the death of some person. So that's why he's guilty. So is it clear, no, Sam? Yeah, okay. I hope it is. So then the next question will go to question 69. The rule is that the actual, yeah, I'll just give you a question as few seconds again to read it. Yeah, okay. So these sorts of questions are fairly straightforward because these questions usually you just have to like compare it to the actual like passage and just sort of look at it whether it's matching or whether there's been some editing for that the question maker has done. Uh, so then you just see where you find this particular sentence in the passage. So then just like do a quick read through like this. So just make sure that for this one you know that and you know roughly where it would be in the passage so that you don't spend too much time searching for the sentence again. So then just quickly do a read through of the passage to see where it was. Yeah. So the act should be of such a nature that it would put to peril someone's life or damage someone's life to such an extent that the person would die. So as you can see, there's been a bit of a cutout from there's been a bit of a cutout from yeah from the actual like passage. So that's why you can say that the above statement is true, but it has some exceptions. Wait, I'm sorry. Yeah. Okay. So that's why the answer is B. So then, which of the following statements is false in the light of the above given passage? Knowledge is given from is different from extent to a certain extent, is intention to a certain extent. I think you can that's yes, that's correct. It's there in the passage here. Death means the death of a human being. It does not include the death of an unborn child, such as this also. Yeah, it was there in the causing death. And knowledge of likely to cause death is also required. So once again, yes, it's knowledge that the doer is likely by such act to cause death. So here, just go one by one. Just check whether they're there in the passage, and if they are, or in case it's false here. So if they are in the passage, eliminate them, and so therefore the answer would be none of the above. So then we'll go to the next passage. Once again, I'll give you guys some time to just read the question. I'll set 3 minutes this time. So try to finish the passage within like 3 minutes at max. Or should we answer true for questions with basic knowledge? Because with basic knowledge, with just try to, yeah, if it's possible, yes, but try not, but like make sure that your basic, like you have a certain memory of what was there in the passage. Don't go and recheck it every time. And if you think that some particular option is like common, with common sense you can not you can eliminate it, then do that. Just but yeah, make sure not to, but if you're unsure of something, don't rely on common on your basic knowledge. Go and check it again. So yes, so the next passage I'll set some time again. So if anyone has any doubts from the whole passage as a whole, if someone wants some sort of clarification, you can ask me now. And yeah, by the way, if anyone has any like just general questions about legal reasoning, you can ask me that as well. I'll go back to the beginning in case any of you have missed it. Can someone give news of death of a son of a heart patient, even if it's true? Um, can you? I didn't really understand what you meant. No, Numman fan club. I mean, so could you please uh, could you please like elaborate on it out? So how to reduce the so Sam again? How to reduce the time taken to comprehend passages on miscellaneous topics? This one, I would say that just try to get some practice. Maybe just go. So yeah, the time's over, but I'll just like answer these doubts. So how to reduce the time taken to comprehend passages on miscellaneous topics? Um, so yeah, this one, it's yeah, I guess there's not much I can say other than practice, but just try to maybe just like if you find some articles on the internet about like these new acts that are coming or something, just try to read them, like if you find it in say Hindu or Indian Express or something like that. So try to read them and time yourself. Like maybe do that when if you're reading the newspaper and you find some like editorial or something which gives an opinion on a particular act that's been passed. So maybe time that and try to look at the legal principles. Like look at where there's a definition, where there's a exception, where there's a particular like a case law and its like ratio or the holding of that case. So try to like just find these particular important parts. So exception is a pretty important thing because that's where they can ask like that's a very easy place to ask questions. So just look at the definition, like try to kind of isolate the various requirements of that section. So like yeah, so look at that. So is it better to familiarize and study all the concepts so it's not alien in the paper? uh I'd say don't. I mean, I didn't really go into every single act that was passed. Like don't. I mean, I don't. Maybe it would work for you, but I didn't do that. So yeah, I don't really know if that would help you much. If it does, then go ahead. So, how many questions did you attempt in your paper? I usually attempted all of them, but I left like one passage, but mostly I mean, except for like maths, I usually attempt and GK, usually attempted almost all questions. For the next session, okay, yeah, this one I can't. I like may ask Anish for that. I can't really help you there. Okay, then. So I'll go on to the questions. So yeah, I'll just kind of break down the passage here a bit. So first we'll go into the definition of what hurt is. So whoever reasons bodily pain, disorder, or disease. So this is the kind of the important parts: bodily pain, disorder, disease. So then, so yeah, those are the main like essentials: bodily pain, disorder, or disease. So once again, any one of these is okay. Uh, So then, bodily pain, according to section 3, the whoever causes bodily ache, disorder, or disease is said to cause hurt. The physical pain means that the pain must be physical. So yeah, that so once again, that's like say a thing that so if someone causes a heart attack to a patient of heart disease by communicating some serious news like death of a family member, um, yeah, that one. I'm not sure. I'd have to read the like actual legal principle of the passage to tell you that. So, um, yeah, I can't really tell you that just like that. I don't really know. Also, I am just scoring four out of five in a passage. That's pretty good. 4 out of 5 is good. So if you, yeah, you can get a good score if you even if you score 4 out of 5 and everything. But 4 out of 5 is a good score. So then yes, I will go. So then I'll continue. Infirmity. So the duration of ache or pain is immaterial. Pulling a girl with her hair would. So yeah. So yeah, it's not. So then again, it says that it does it that only pain has to be inflicted. It doesn't matter what your uh what the what like how what the duration or the intensity of the pain is. So then infirmity to another. So bad state of frame of mind and state of transient or hysteria or terror. It's an incapability of yeah. So it is an incapability of an organ to carry out its everyday function. Maybe so yeah, this is kind of straightforward. So the bad state of frame of mind, transient intellectual impairment, hysteria or terror. So these are the sort of keywords you have to keep in mind. Incapability of an organ to carry out its everyday function, and administration of toxic or poisonous substance, or taking alcohol. So infirmity, bodily infirmity to another means that there is a like there's a temporary or complete impairment to to the functioning of an organ or to some state of mind that is not complete. So that's the kind of the gist. Disease, a communication of ailment or disease from so yeah, this is pretty straightforward. You can understand what it means. So yeah, it says that, I mean, this is an exception that the transmitting a sexually transmitted infection it's kind of unclear whether it would be part of hurt, because there's another section that deals with this. So then the reason here is also given because so this you can use as a general principle, because the interval between the act and the sickness was too far away to attract. So yeah, like for example, it's kind of the time period needs to be more immediate. That's the kind of the gist here. So intention. So the person intentionally sets to shock someone with he said to cause hurt. So again, so yeah. Uh, okay, so your overall score is 4 out of 35. I mean, I can't. I think you can. I don't really know how to help you if, uh, with just the score. But I mean, I'd say you just try to practice as much as you can. Try look at your mocks and see and try to analyze them as best as you can. And uh, like at least here, try instead of just trying to do more and more mocks, just look at kind of answer your mocks again and kind of go out deep into every mock before you attempt another one. So try doing that. But yeah, I'm not sure. Without more specifics, there isn't much I can say. So if you have a mentor, kind of discuss it with them or with your teacher or someone. See where you're going wrong. So yeah. So B had a so this one, let's go to the first question. I'll give you 10 seconds to read it again. So yeah. So I mean here in all the questions here, there's a bit of a mistake. It says grievous hurt, but it's just hurt. Grievous hurt is not mentioned in the passage, and it's a completely different thing. Uh, so yeah, let's go to the question. Once again, C and D you can safely eliminate because they are very they are the kind of very vague options. So again, once again, it's based on has he caused it or has he not caused it. So you can usually eliminate two options and it will lead to this. So yes, you can. This is a pretty straightforward thing because it's disease. There is an intention. There's an intentional communication of disease from one individual to another. So yes, so the answer is B. This is relatively straightforward. So next 72, A and B got into a fight. Yeah, so I'll give you time. So I hope you guys have read this. So we'll go into the quest options. So once again you can eliminate C, because serious bodily injury is not is not part of any principle, nor is it an actual like offense or anything. So A or B got, so you can see that he said that he will bash the daylight out of B, but then he got scared and running into a ditch and and hurt himself. So uh then again, whoever reasons bodily pain, so once again he did not, this person did not cause the bodily pain or injury, did not cause the hurt. So he's so and second of all, the second, there is no intention, there's no intention for that person, for that particular act to happen. So here so that's there is no hurt. So yeah, B is the answer. So yeah, next question, I will go into that. Yeah, okay. So B has not committed. This one again you can eliminate, because cheating is not part of the principle, that goes out of the principle, so you can safely eliminate it. So then so yeah, has he committed hurt or has he not committed hurt? So let's look into so let's look into what exactly makes the important part of this question is. So so there was a cause, the cause is direct, that the portion has caused the kidney failure. And now we can see that what the ambiguous part of the question is. The ambiguous part of the question is intention. So we look into whether this person intended to cause this particular hurt. So uh so yeah, again here we'll probably have to differentiate motive from intention. So intention only refers to the whether the act was intended, and not necessarily the consequences of the act. So uh it was intended to administer the portion, and so this was, and so you can say that, so here again you can say that this is he has committed hurt, because there is a direct cause, and there is intention to give that particular portion and to do the act which caused hurt. So then we can say that so the answer would be A. So you guys have any doubts here? Okay. Okay, then we'll go on. Which of the following statements is false? Intention is immaterial. So, I mean, this is obviously false, but we'll just read the remaining questions. According to section 319, so yeah, this is correct. There's no radical difference between assault and harm. So, once again, this is like just completely uh, this is kind of out of the passage, right? I'm not too sure, but yeah, it's kind of out of the passage, but it's not false according to the passage. So, therefore, it's A. Uh, in 73, he didn't have the knowledge that his act will cause hurt. I mean, yeah, that is, it's not really necessary for to know that the act will cause hurt, that will cause some particular hurt, if but but he believed it to be medicine. So that doesn't necessarily protect you. That just think like a sort of, that's kind of just a mistake of fact which would not necessarily protect you, because uh, there was he kind of had the knowledge of the act, and he sort of, so he, just because he believed that it was medicine doesn't really mean that that doesn't really necessarily uh doesn't really absolve him of hurt, because he had knowledge about what he was doing, and he had the intention to do what he did. So that's what's important. Don't look into the sort of the background motives or the background reasoning for that person for doing the hurt. So this is, I mean, this is just sort of general. Uh, yeah, there is no there is an intention, because he did that's there's no motive for that person to kill, but there is an intention for the there is an intention to do the act which causes harm. So there's a difference between, like, say, motive. If someone like say, if you, it's still, suppose you stab someone, but then you say you thought that the stab would that the knife would actually would actually cause some, say, some exorcism. So that would still be that you would still cause hurt there. It doesn't matter for what reason you did the you stabbed that person. It only matters that you stabbed that person and you intended to stab them. Whereas on the other hand, the difference is, like, say you accidentally threw you accidentally threw the knife, and it like, because you sort of, it slipped from your hand and it went and hit that person. So there's a difference there, as there's no intention for you to cause that particular act. Whereas you can look at whether the act was intentional, not whether the consequences of the act were intentional. So yeah, I hope you understood that. This is more of a general principle of law, of especially in criminal laws. So yeah, just keep that in mind for intention, the difference between intention and motive. So we which of the following might be a method through which infirmity can be spread to another person? There's no hard and fast rule. And infirmity can be spread. Yeah, I mean, the this is, see, that's what's, yeah, I mean, this one, see, that's what's given in the passage. So yeah, I mean, it's kind of direct. So then we'll go to the next passage. I hope you guys understood everything. So if you have any general doubts about the passage, you can ask me now. So I'll just set the timer for the next passage. And yeah, I'll be back in a minute. Yeah, okay, so the time's done. I will. Yeah, I have. Yeah, okay. So if you have any doubts, like here we can like you can ask. I'll go through it. So these types of long passages, as in like what exactly do you find difficult about these kinds of passages? So yeah, we'll go into the questions. So I'll give you question 76. I'll give you some time to read it. Yeah, these sorts of passages are somewhat are kind of a bit difficult in that sense. So we'll just go through the questions and we'll kind of see if you have any sort of mistakes that you have made. But for these sorts of things, I'm not. I'd suggest just kind of like going through the questions and then seeing, and then if you kind of don't recollect what, if you're kind of at a loss of what to apply, you just sort of go back to read the passage. So yeah, we'll go to question 76 first. So the main thing here is that the state of Z has brought in some rule that says something, and then the center has brought in another law which says something else. So it's concurrent. It's in the concurrent list. So we go to the passage and look at matter enumerated in the concurrent list can be legislated by both state and centers. However, the centers takes precedence. This is the doctrine of repugnancy, but yeah, that's not part of the uh, passage. So the here we say that see that if a matter is on the concurrent list and it has been legislated on by both the state center and by the state, then the center's law takes precedence. So then here obviously obviously we see that the law passed by the state shall, I mean, this is, I mean, say the legislation made by the center shall prevail over the one created by the state government. D. So how should we break the passage to make it more understandable? Um, I would just suggest kind of going through the questions and sort of going back when as and forth necessary. These sort of passages, yeah, take a bit more time, just like kind of be a bit slower with it in case there are a wide variety of rules and sections given in the passage. So if the union government opines that a certain legislative action is incorrect, what is possible to, so then we sort of go back and see what the particular principle is. So yeah, Article 256 is the principle. It lays down that the executive are to be exercised in such a manner that it complies with the laws made by the parliament or any existing laws. The executive power of the union includes in its ambit such directions that are given to the state by the central government which it deems necessary for the purpose. That if the states duly comply with the first part, then the second part does not seem necessary. Whereas this serves its part, sometimes it's evident that the states are guilty of violating the first part of the provision. The constitution lays down this provision on the assumption. Okay, so this, yeah. Um, so yeah, like just just sort of if you guys have any specific doubts in this section, in this particular part of the passage, so if you didn't understand some particular part, you can ask me. Yeah, okay, then I um so yeah. So the union government opines. So we look into whether it fits these particular principles. So we'll see first there's a question given about there's a sentence given about emergency. So we'll see if it fits that. If it does, then we'll go to that. So uh, that to explain, if a state fails to comply with the directions issued by the center, then it is lawful for the president to hold that a situation has arisen wherein the state government cannot be carried on according to the provisions of the constitution. So here it just says that the government has opined that a certain legislative action is incorrect. It does not say that the state has not abided by the directions of the union government. So you can't. So this is this does. So then we can eliminate this. Uh, the option related to the emergency. So A is eliminated. So then again we can eliminate C because there's nothing mentioned about joint assembly, and the passage is not dealt with the said issues also wrong. So then the answer is obviously B, but then we'll go back to the passage and see where the particular principle is. So the so yeah, here it says states that the executive power of the union includes in its ambit such directions that are given to the state by the central government, should deemed necessary for the purpose. So that's what is the exact passage. So what are some of the good sources for legal sections? Sources as in like what you want to read before. You don't have to really read much before. Just if you keep up with the news, then you can perhaps get some of the you can get some of the those miscellaneous section type questions. However, for torts, I'd suggest just go through some like very basic legal articles for maybe negligence for some of the basic torts, but don't spend too much time on reading law because that's not what you're expected to do. But however, but for like say contract act and for contracts and criminal law, you can maybe go through the Bear Act for some parts of it, like some of the most important parts, like in contracts. I'd suggest go through the part of related to the acceptance and they sort of give an experience that based on when exactly the contract is accepted and when exactly the contract is proposed. So in that sort of way. So we best books for practicing legal reasoning. I'd say just focus on your in your coaching material. Don't try to collect material. Whatever you have, you just make sure to finish it first. So whatever your coaching has done, just one like it's as good as any. You don't have to kind of search for the best books. Mocks are probably the most important part. Taxman's book for legal. I've never heard of this before, so I can't say. So then we'll go to the next question. How the Constitution cautioned the state to exercise their power in such a manner which, yeah. Yeah, I mean, this one, we can see that it's 257 one. It's just the same as the question, as the passage. So you just have to compare. Yeah. So yeah, it's C. This one's a direct question. So which of the following statements is false in the light of the above given passage? Yeah. Okay. So I mean, these three you can all see that all three are correct. So you don't. This one, I mean, as one of you asked before, if basic knowledge is enough. Like for these sorts of questions, this question in particular, you can see that just be with reading the passage once, you can generally see that these three are all there in the passage. So then you can answer D. So then we'll go to the 80th question now. Okay, then. So first of all, we can just say the we can eliminate A. The send in troops is obviously wrong, and this impose a dictatorial regime again, once again, definitely wrong. So quasi-federal country union does not have any options. So this is again, it's kind of raw. Like it's kind of a there's no justification for this. So we can eliminate B as well. So this leaves C. So in this question in particular, you can sort of, without really reasoning it much, you can jump to the answer. Uh, but if you guys have any doubts with regard to the reasoning, you can ask. For lengthy passages, should we skim the passage and then come to the questions? Yeah. How to find principles in the passage which are stated indirectly? So what indirectly, as in like in what sense? Could you like elaborate? So yeah, we'll go. So now this passage is done. We'll go to the next passage. I'll just put my timer again. Legal CA for which the um, uh, I mean, I get like I still don't really understand what you mean. Could you like tell exactly what you have a doubt in? So yeah, I mean, if you guys have any doubts for what we have done so far or for legal reasoning in general, you can ask. Don't have to. Yeah, it doesn't have to be related to what we are doing at the moment. So if you wanted to ask some doubt for a previous question and you missed the opportunity, you can go ahead. you have a difficulty in finding the principles. So I'd suggest, like, if you have a difficulty in knowing what exactly is important, if that's what you mean, just sort of look at the where you can find definitions, sort of break down the definitions and look at the exceptions. And so sort of just go just sort of look at kind of find these particular things in. So uh so yeah, just try to find the try to find these sorts of key parts of the passage. So the time's over, we'll go to the questions. So yeah, this one's pretty direct. There's a direct mention of the correct option, so it's right here. So yeah, the answer is C. So then we'll go to question 82. So which of the following statements regarding Hindu law is false? So this one is correct. As you can see, it's three. Then and that limited estate property. The most important progression with respect to women under Hindu law happened in 2005. Um, it's here. And previously, daughters were not entitled to the share of any share of inheritance except for the small amount in the form of strida. Um, so I mean, again, this is correct. So yeah, it's 82 is D. So how has the rights of women revolutionized under Hindu law post 2005 amendment? Um, so yeah, as you can see, the it's over here. I I'll give you a few seconds to find it. So yeah, if someone can like say write the answer if you before I go there, if you so and so that I can like say so that I can see if you guys are uh, understanding what's going on. So yeah, the answer is C. It is B. That's what's there in the passage. So then we'll go to question 85. So yeah, once again, it's there. This is straightforward. The Baga inheritance. So he sort of he doesn't necessarily. So then I can see that there might be a confusion between B and C. So what I'd say is that it's not. So yeah, I'd say that it's not C because he criticizes Mitakshara and Dayabaga systems for this particular aspect, but like not the Hindu Succession Act. The question is whether how the Hindu Succession Act has been criticized. So the author they say that the Hindu Succession Act is based on Mitakshara and Dayabaga inheritance, and the Mitakshara Dayabaga inheritance so has this stereotype at mind. So I hope Megha and Tanaya, I hope you understood that. Okay, so I'll move on. So now we have a passage on misrepresentation, the fifth passage. I'll set the timer again. Um, Tanya, I think if you're referring to the previous question, yes, it's B. So do you think CL marks are in par with the? I did mostly CL marks in my preparation, and it was I found that it was in par. But if you might have a different opinion, like I don't. Uh, I heard that legal edge tends to be harder. Okay, the time's over, but I heard that legal edge tends to be harder than uh, CL. I guess if you want to do that, then do so. But yeah, I found that CL marks were kind of more similar to the CLAT pattern. I didn't really do any legal edge marks though, so I can't comment on that. So we'll go to the first question. So you guys first read it and then you give me a how many marks should we attempt. So that's a very subjective question. It depends on your requirement. It's probably more. It depends on how comfortable you are with doing. I just only did 1 mock a week. I never really did more than that. However, if you feel like you need to do more, then do that. But I wouldn't say that there's any sort of, you don't have to do like say multiple mocks a week. You don't have to do it if you don't feel comfortable with that, or if that's too tiring for you, then don't do it. Do you suggest attempting mock of two institutes? Maybe, yeah. Depend, like, may focus on one, but yeah, like even I did law prep. I did like I did a few mocks of that, but like so that you can like don't get too adjusted to one with the questioning style of one institute. But you for do don't collect material. Just try to focus on one or maximum two. Don't just try to stretch yourself too wide. Don't accumulate material. That's one definite thing I'd say. So yeah, if you guys have answered the question, you can put your answer down in the chat box. So yeah, so then we'll go into this question. So here what he said that these were the best bags and it would easily last up to 2 years. So so this statement was what would is what influenced R into buying the bag. So these were the best bags is a statement of opinions. So we will not be so how many? So yeah, all three of you guys are correct. So how many mocks did you give throughout your CLAT prep? I gave somewhere around 45 to 50. I guess I prepared for 2 years. So um, lag. So was I not audible? The part what I just said. Okay. Uh, okay. So yeah, you guys are correct. It's option C. So we'll go to the next question. And yeah, you guys have the file, right? So I'd suggest is the next three the next three passages. Uh, so yeah, the next three passages what I'd like suggest you guys do is that you solve all five questions before. I'll give you say like 10 minutes time, and then we'll go through the questions and then see if you guys went wrong or something. My voice is still breaking. Can someone else confirm that? Okay. So, I mean, uh, okay. Anyway, I'll continue. So what I just said, anyways, for the last three, since you have the file, I'll just so yeah, I'll just send it back again if So this is the file. I'll just send it in the chat. I can't. I don't know how to send something in the chat, but it's in the beginning of the chat. If you don't have it, then yeah. Okay, so it's at the beginning of the live stream chat, so you can find the link to the of the PDF of the yeah. So yeah, we'll do that for the after we'll finish this passage. After that, we'll just can you guys do all five of a passage, and then I'll discuss the answers to see where if you guys went where you guys went wrong. Okay. Uh, so we'll see this. We are 87. You guys can write your answer if once you solve it. I'm not sure how exactly to send the. Yeah, it's in the description. Okay then. So yeah. Uh, so for this one, we'll look at whether there was a misrepresentation. So what he said is that the TV was working perfectly well, and it was the best TV. So this one, it's more of a case of opinion, right? So there is no proper misrepresentation here. It is not unwarranted. You can say it is not a statement made without any without an unwarranted without any reasonable basis. And he did not act in any sort of unreasonable manner. All he did was furnish his opinion, nor did he induce a mistake. He only stated his opinion. So yeah, the answer is the answer would be A. Oh wait, no, I'm sorry. That's the wrong question. He the answer would be the answer would be C. Correct. So we'll go to question 88 now. Okay. So I hope you guys have read the question. So here you can see that he had no idea about the market performance, but his friend had still assured him that the said company was doing extremely well. So then we can say that this is a sort of unwarranted statement. It was without any reasonable basis, without any trustworthy source of information. So it is not called for under the provided circumstances. So this person has made a statement without any reasonable basis, right? A reasonable person would not make that statement as he does not know about the performance of the uh, company. So yes, this is he has caused representation of subject matter. So yeah, now these two are the remaining questions are the sort of just true or false questions. Inducing mistakes about. So yeah, you guys can just write your answer for the next two questions if you. Inducing mistakes about subject matter involves mistakes of fact. So yeah, this is also yes true. Even if the contract cannot be declared void. Let's yeah. Um. So yeah, I mean, if the misrepresentation is identified, the contract can be declared void. So yeah, that is false. So yeah, the answer is C. When does a breach of duty occur which gives rise to misrepresentation? So yeah, I mean the answer here is C. It's relatively straightforward. So you guys have like, can you guys confirm if you have the file? Yeah, you guys are correct. Tanaya and Mega, you guys are correct for both of them are C. So can you guys confirm if you guys have the file so that yeah, okay, good. So then just do passage 6, and I'll you guys can take about say 7. uh like I'll like this is a bit much for the actual exam, but you guys can take about 7 minutes. I'll so then after that I'll just go discussing the answers one by one. So see, don't write your don't write your answer until like I come to answering that question. Like so that so that when I actually come to discussing that question, you guys can answer it. And if you guys have made a mistake, I'll kind of give like try to defend your answer so that I can see if you have made where you're like if you're going wrong somewhere. So then I'll just set the time. You guys do pass at 6. Okay, 7 minutes is over. I hope you guys have solved the questions. So I'll just go one by one. So then, like, write your answers for for question 91. Um, so what is the law? What is the case of Mala Baksh versus Union of India do in terms of development of Section 74? So, so the expression whether or not actual damage or loss is proved to have been caused thereby is intended to cover different classes of contracts which come before the courts. In case of breach of some contracts, it may be impossible for the court to assess compensation arising from breach, while in other cases, compensation can be calculated in accordance with established rules. So, um, yeah, so I mean, it does not dilute the law of in Fateh but further clarifies that there may exist different class of contract, so which Fateh may not necessarily apply. Uh, so yeah, I mean, the answer is B. So I hope you guys got that. So which of the following statements is false in yeah. So which of the following statements is false in light of the above passage? The law on liquidated damages is correct. They came for consideration with the other two. So um so yeah, like this one is dubious. So section 474 has been analyzed by court in one particular manner. Okay. Where a party suffering breach was in position to prove that its loss situation Fateh would apply. Uh, yeah, so then D is not the answer because it's true. So uh, yeah, this one, the decision came up for consideration before the Justice J.C. Shah himself. This is also correct, yeah, and because yeah, I mean it's here. So this the answer here is C. 92 is C. Correct. You guys are nine. Okay. So 93, which of the following contracts are considered different kinds of contract? The contract which has not been applied and being considered. Contracts in which the damage is not being asserted. Uh, so I mean, different class of contracts are the ones where it may be impossible for the court to assess compensation arising from breach, and in such situations, the sum name, if it regarded as a genuine pre-estimate, may be taken into consideration as the measure of reasoning power of. Yeah. So yeah, I think you guys are correct. It's 93B. So then we'll go to the next question. Which of the following statements is intended to cover different classes of contract which come before the courts? So, So yeah, whether or not actual damage or loss is proved to have been caused thereby. So yeah, it's 94 is A. Yes, you guys are correct. So now 95. When can a genuine pre-estimate be taken into consideration? Uh, so then where it may be impossible for the court to assess compensation arising from breached and genuine. So yeah, I mean it's C, correct. Yeah. So yeah, so that's the this passage. You guys have any doubt regarding this? So yeah, I mean this is a all the questions are like true are fact based. They don't have much leeway for ambiguity. So I guess this one's this one's not. If you can understand the passage, then the questions are straightforward. So then we'll go on to the next question. Once again, I'll give you guys 7 minutes to do the next passage, the seventh one. So then I'll start the time. If you guys don't have any doubts on this passage, and if you have any doubts, you can ask me in the coming 7 minutes. Okay, so the 7 minutes is over. If you guys have any doubts, you can put it in the box in the chat. So I'll I'll go ahead and start solving the questions. So according to the author of the passage, whether the state has been justified in using technology, facial recognition as monitoring system, uh, the passage remains neutral in terms of the opinion. The passage opines that the states using FRT as a monitoring mechanism is not within the exception. Opines is within the right to privacy. Then the suggests that the rights of the state changes from one situation to another. So so yeah, beyond privacy, there is a. So yeah, I mean, I guess you. I think you're correct. The answer is B. It is not within the exceptions of the right to privacy. The author has a clear opinion that that such a usage is unconstitutional. So so then we'll go to the next question. So which of the what is likely to shape some important principles for responsible use of AI in India? Further analysis of the case of K.S. Puttaswamy, the upcoming cases of FRT are likely to shape some important principles. The decision, the PIL filed by the passage does not discuss the same concept. Responsible use of AI. Uh, it is the first constitutional challenge to the usage of FRT and is likely to shape some important principles for the responsible use of AI in India. Uh, the Civil Rights Act is filed petition. Yeah, so yeah, this is the answer. The decision in the PAL failed residing in Hyderabad for the responsible. So answer is C. I, yes, you guys are correct. Mega and Tanishka, you guys are correct. So then 98, which are the following when so since when has the right to privacy been read as a fundamental part of Article 21? Um, so let's the that this is let's see what's written in the past. Since 2018, landmark judgment of India informational privacy. So yeah, this is the answer. That's correct. Yes, it's 98A. So yeah, Shrishti, you said that 97 is. Oh, wait, sorry, I'm correct. You are right. I'm sorry. I. So yeah, you said that 97 is C. That's correct. So yeah, 98 is A. 99. So we'll solve 99 now. That is, which of the following statements is false in the light of the given passage? So yeah, all three of these statements are correct. So the answer is D. This is pretty straightforward. So we'll go. All you guys are correct. So 98 is A. You are yes, you're right, Srishti. So yeah, 99 is D. So we'll move on to the 100th question. What is the opinion regarding the public interest litigation filed by the Hyderabad? Uh, so he does say that the petition does fail to raise three significant issues, and the petition is going to play. So yeah, so the answer here is D. So he the petition says that the so yeah, I mean you guys Mega and Venkatesh, you wrote B. So the I think you probably missed the you missed that the like the author says this about the petition. So he does they do state that the petition fails to raise three significant issues. So the answer is D. Yeah. So yeah, the answer is D. It's both A and B because A has also been mentioned in the passage. So then now we have the last passage, which is passage 8. So you guys again go through it. I'll set the timer.
Shivaraman, I think it's fine. We can do with only 7 passages. I think we
Yeah.
can skip the last one. We can clear some like general queries if they have. So
Yeah.
basically, some people wanted to know like only 2 months are left. What should be the frequency of mocks? You can close this. Uh,
Yeah. Okay. So
yeah. So
for the
people wanted to know like what should be the frequency and should we rely basically on CL or we should look at other sources like even NLTA provides mocks now. So should we have a combination of all these 3 4 institutes and then give mocks?
try to focus on one particular source, and if you do try to create, if otherwise try to create a plan for how many marks you'll do of and what kind. So try not to just stretch yourself too thin by downloading like 20 different like uh, institutes mocks. Try to keep yourself to maximum three, like whichever one you have, it's as good as any at this point in time. You focus more on keeping yourself to the time, and analyzing where you went wrong in the mocks. Don't just it's while there were differences, I find that they weren't that significant. You can do whatever you have. There's not too big of a difference. So but
Right.
do try to like maybe do another mock, or do a few mocks from a different institute, so that you can get acquainted with different forms of questioning. So that's my advice there. And now for your for how frequently you should do mocks, I guess it depends on how, like, do you are you like at the score where you want to be. So that's your, like, kind of see whether you are kind of hitting your goals. And if you think you're a bit inconsistent with, like, you're hitting that goal sometimes and sometimes not, then try increasing your frequency. But I never did it more than once a week. I did it twice a week sometimes, but that might not work for you. You might you might in fact want only need to do it less than me. You might need to do it more. So that's dependent on your need. So just ask you. So there is no hard and fast rule on whether you should do more mocks. So if someone is just telling you that you have to do 2 mocks a week or 3 mocks a week, then don't listen to them. It depends on what you need to do. So yeah.
Right.
So
Right. Also, Shivaram,
it
so
depends on your,
yeah, continue.
yeah. So it depends on your need, how exactly you want to pace your preparation. So yeah, you were saying.
Yeah, right. So I wanted to like ask this another question that only 2 months are left. So what should be our priority? Revising like theories of CR, English, legal, or our priority should be practicing more questions? What do you think should be our goal?
I would say, yeah, do spend some time on revising the fundamentals, the theory, and especially GK. Try to like revise some of your old the stuff you may have forgotten. Uh, as per but yeah, I do try to practice as much as you can. Even GK practice will help you, will help you remember old GK more than just like reading your notes again and again. But do read it, like if you find that if you think you don't remember something, then go back to that section and read it. So as for
Right.
Mega, how to cover GK CLAT 24. So for 2024, I'd suggest, yeah, like you, it's going to be in December itself, right? Even in
Next
24.
December.
Yeah. So
Yeah.
then like maybe try, yeah, like for now, just I think, if you are you already doing GK, in which case just try to focus on the process. But for the actual like for 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 the actual like GK, what you have to, when you actually have to start, I'm not exactly sure. Just ask whoever your mentor is. But I think it should be somewhere around January. Yeah. Uh, so Venkatesh is, Yeah, okay. So whenever the passage contains the stuff you already know, should we should go back to the passage or just there? If it's already if you stuff it's already know, then just skip it. Skip it. I've done that a few times with legal reasoning. When it's something like say negligence, which I've already read multiple times, just you can just skip the whole thing. Uh, but yeah, like just see if you can make if you can if you have that like the trust to make that skip. So Tanishka, you should 2024 aspirant give CLAT 23. That yeah, I mean, if you want to, you can go ahead. I didn't do that, but that's because I didn't know that you could do that. But I guess go ahead. There's no harm. So
Yeah.
which sources should we cover for GK? Your CLAT your institute's material is as good as any. Don't make yourself do like 3 4 uh, sources, and make sure to read the newspaper regularly. And I also, what I did was I sort of took a topic list from like seeing it on the news or whatever, and sort of covered it by looking at like Wikipedia and Drishti IAS and and like Hindu. So that was my main way of doing GK. uh Drishti plus Manthan and Clat post, that's good enough. You can do that. So yeah, as for direct question, should be fact checked? Depends. If you think if you're sure, then don't. But if you have a bit of uncertainty about about the facts, then yeah, do that. But try not to.
Right. Thank you so much, Shivaraman, for taking out time and taking this session. It was really an amazing one. Thank you so much.
Yeah, thank you. Yeah,
Thank you. Yeah.
thank you. So yeah,
Yeah, you
see
can
you
leave the
guys.
session.
Yeah,
Thank you.
thank you.
Right, guys, that was it from our first marathon based on the legal reasoning section. We'll be coming up with more such sessions, specifically English and CR, and you'll be shared the details pretty soon. If you have any doubts regarding the National Law Training Institute and the GK booklet that we are coming up with, please feel free to reach out in the comment section right now, or you can reach out to me on Telegram using my username Anish underscore 1507. Yeah, just to inform you guys, we are coming up with this GK booklet that comprise of 2000 questions from January to September. And from January to September is the first part, and the second part will be delivered in the latter half of November. So if the cost is rupees 2000, in this you will get two booklets of GK comprising passage based questions, 2000 questions, and this would be the first part would be delivered to you by 26 27 October, and the second part would be delivered by in like 1st December maximum. So this would cover everything, and if you have not touched GK even till now, you can probably rely on the GK booklet, because that will consist of 2000 questions, and most probably every topic that CLAT can ask should be covered in that booklet. Also, one suggestion for future batch, like compile mentorship mocks material GK with 10K, 15 separate. I couldn't really get to your point, Venkatesh, but yeah, we have combined already this all these courses. You can reach out to me on Telegram if you want to know any such thing. Yeah, definitely. We have a course which includes mentorship, mocks, plus material, plus the GK booklet. Please reach out to me on Telegram. I'll inform you about that. Right, guys. All right. Thank you so much for taking out time and joining us throughout this session. It was really a pleasure to have you here. And thank you for considering this worth your time and patience. Thanks a lot. I found this question important. So, yeah, I wanted to answer this. Mega, is coaching necessary for CLAT? Not at all. If you think you will be able to sail through CLAT without any coaching, that's sufficient. Primarily, CLAT is a reading oriented session, and coaching cannot make you read. Coaching can just help you read. And that if you do not need that help, and like most of the CLAT aspirants who clear CLAT do not need that help, that is fine. You do not need coaching necessarily for to clear CLAT. If you are an avid reader, if you are not, develop this habit of reading. If you are already an avid reader, that's great. Just read newspaper daily. Just refer GK sources. You can use YouTube for quantitative techniques, that is maths. and basically reading could be legal reasoning could be like developed upon by giving mocks and sectionals. So yeah, you do not need coaching for like studying, but you need coaching for mocks because mocks are indispensable and imperative for CLAD. Test series will definitely suffice. If you get a test series from any of the renowned coachings, it is fine. You do not need any coaching. Cool. Cool, guys. Thank you so much. I hope that you found this session enlightening and helpful. We'll be coming up with more such sessions soon. Thank you.